Well, ladies and gentlemen, we are live again. It's been a couple of weeks. Last week, you obviously didn't see Angela or I. We had Nikita, Mia, Dylan, and Stefan running the show, but we're
Had a
back now.
break.
We haven't retired from this, so good to be back. And I think I might have lost Angela there for a second, but there she is. She's
Sorry.
back now. How are you, Ange?
Good, Kevin. How are you going?
Really good. Extremely busy, and also just running around. It was and probably first things first, we need to talk about what happened last Sunday, because Daniel Andrews came out and announced that we can do private inspections again as normal. So that was a big shift. I mean, the announcement came
amazing.
and when we saw everything on TV, and we didn't think we were going to be allowed, because nothing really got mentioned. And then all of a sudden it was like, yep, from midnight tonight, you're good to go. So we were just frantically trying to put everything together over that weekend and Sunday and Monday. So how was that experience for you?
Wasn't it the best news? Seriously, I heard it. I was helping out Mum, and I was just overjoyed, as was every single agent in Victoria, just overjoyed the fact that we can get back to some sort of normality and business, and just letting our clients know that, we can start working for them once again. Like, enough of this virtual stuff, which was working great, but let's get into the physical inspections and drive these buyers to the properties and get some results for them. It was great news. Created a lot of work for us, but it's exactly what we needed.
100%. Couldn't agree more. And it was so interesting, because the uptake from that point has just been out of control. Like, we've had so much inquiry come through from people, that were obviously waiting for properties to come to market, and also people that just couldn't buy or do anything for an extended period of time. So now all of a sudden things reopen, and I'm so pleased to report the first week, starting obviously Monday through to tomorrow, which is Saturday, we have in excess of 100 inspections booked as an office. So this is absolutely fantastic. It almost feels like it's incredible. The crazy spring 2017 market again. So a lot of great buzz, and we talk a little bit to our vendors when they're preparing their property for sale or getting it ready, or they're in the process of choosing an agent. We talk a little bit about layering as well, as to that the first step of getting a buyer is to get a buyer excited, and it's almost theatre. A good agent is extremely good at creating that theatre. And the second step is then building up the hype. And that hype is certainly here. I mean, the hype is there. We've got buyers lined up one after another at these properties. There's some properties where there's 14, 15 inspections, one after another, happening tomorrow, with all precautionary measures being social distancing and sanitizing and face masks and all the rest of them. We've actually got some Ray White branded face masks as well. So a bonus tip at the end of this, I might show that to everyone. And if you would like your own Ray White face mask, we're giving them away for free. So,
happy to give them out.
Reach out and pop a comment below and say you'd like a mask, and I'm happy to send it out to you, or give it to you when we see you around. How has your week been so far, just obviously tackling everything that's happening?
Yeah, it's been super positive. Obviously, when we thought we were going to be released, going back a couple of weeks ago, I think it was meant to be the 19th of September, we had a full calendar booked that day. So it was basically drawing upon those inspections and contacting all these people and sending out all these bulk messages, and the responses just kept coming in. So just like you, we've got between 15 and 20 inspections just for tomorrow booked. So back to back, and the inquiries keep coming in. So it was great trying to organise all of these inspections, and I guess making sure that we do allow buyers enough time to see them, but also being mindful that we're only allowed up to 15 minutes. So just being mindful of all that. Vendors are very excited to come back on board, and it's like it's our first day back at school tomorrow.
Yeah, I know.
It's
a bit emotional, actually. A couple of days ago when I put on the suit and I was ready to go to work. It was quite interesting. So you're 100% right. It's just feels like a new territory. Although this is what we do all day, every day for a living, it just feels like we've been so used to doing virtual inspections and virtual appraisals and all the rest of it. For the buyers that might watch this as well, you are allowed to travel outside the 5K zone, provided you're going for an inspection, and we can send you a confirmation text. You've got something in writing. But talking about the laws and the legislation and all the changes, I think today, this is a perfect segue. we've got a really special guest. We do a lot of work with him. He's also a friend of mine. And he talks about something that is super crucial, sometimes gets forgotten about, but one of the most important things in a transaction. In fact, a transaction cannot happen without this person being involved on both the vendor side and the buyer side, and that is a good lawyer or a good conveyancer, whatever you call it. And their job when you are selling a property would be, they'll prepare your contracts and your Section 32s and stuff, which is the most crucial. I mean, if there was an offer, if someone comes and offers you the price you want, you can't take it without a contract. But the contract is where the offer gets written. The buyer legally can't make an offer without looking at the Section 32. Same from a purchaser point of view, they'd have to employ someone to make sure they are getting the property that they were promised and everything goes nice and smooth and the funds, go in the right spot and all those sorts of things. My dog is going nuts because he knows Scott Goodman's coming. And when the people hear, including my dog, Scott Goodman's name, people start getting shaky. And so is my dog. So without further ado, here we have him, the main man, Scott Goodman himself. Welcome, Scotty.
Good morning.
Scott.
Good morning, guys. How are we?
Really good.
Really good.
Thank you for the invitation to come on today with you and discuss the important roles of the legalities of buying and selling real estate. It's an absolute pleasure.
Thank you very much, mate. Thanks for having coming on board. We're actually going to be watching. So as soon as I mentioned your name, the numbers kind of went up a bit, which is awesome. So here we go. And for those of you watching today, guys, if you've got any questions, legal related, anything that you think, someone like Scott Goodman can answer for you, pop it in the comment section. We'll be very, very happy to answer them as well as we go. But welcome, Scotty. We've got lots of questions to ask you today.
Absolutely. So today we're going to cover off some really important questions. There's always two sides to a real estate transaction. That's the vendor, and then we've got the purchaser. So we're going to discuss all the legal intricacies of and bust a couple of myths while we're at it.
Yep. Okay. So let's start off with what's the role of why is a lawyer so important in a transaction?
Absolutely. So in dealing with buying and selling real estate, first of all, a house is going to be listed for sale. So your real estate agent, like Kevin and the team, are going to list a property for sale, and then at the end of the day, you're going to require a Section 32 vendor statement. People colloquially know them as a 32, and in essence, you can't enter into a legally binding contract of sale unless a Section 32 is prepared. So as soon as you've got an agreement with, as soon as the real estate agent's got an agreement with the vendor, you should be getting that straight away because you're going to miss opportunities. We identified that as a number one priority within my firm. And what we do from that point of view is we have an internal service level agreement with ourselves. We want to get that 32 out within 24 hours tops. We generally get them out if we receive an urgent phone call. Someone says, I needed it yesterday. We'll generally get it to you within the hour. And that's on the basis that we've got the full instructions from the client, of course. And we go through a bunch of vigorous questions that we will ask the client, the vendor. And those questions can seem sometimes a little bit innocuous and sometimes a little bit, why are you asking those sorts of things? And what it comes down to we've settled in excess of 20,000 property transactions for people in Victoria and interstate. We do property conveyancing in every single jurisdiction in Australia, so across every state and territory. And out of all those transactions, we've learnt to ask the right questions to make sure that we cover every possible scenario that our client could potentially get tripped up on a transaction, because our number one goal is for the vendor is they want to achieve an unconditional contract of sale as soon as possible. They don't want someone having the opportunity to withdraw from that sale. And the reason why that's important, apart from the bleeding obvious that yes, you're going to miss out on a sale that's there, but most of the time we don't have enough money to go out and buy two houses and have the privilege. So we've got to do a swap, essentially. We sell our house and we go out and buy another house. And so people, once their house is sold, they'll go out and buy another place and have a contract on that. And if the first one falls over, it's a domino effect. And then we start to see settlements crash. We don't want that. We don't want our vendors having contracts fall over because of that they haven't obtained proper legal advice. I should highlight some interesting statistics for you guys. as solicitors, there's two types of people that can prepare, do conveyancing works, and the Section 32s. There's conveyancers, and there's also two lawyers. I originally started out as a conveyancer, and then I crossed to the dark side and became a lawyer. That's why I'm in black.
Oh no, I am the definition of the dark side.
You wear your mask and do the heavy breathing. Get your lightsaber out. I'm a big Star Wars nerd, but I can give you some interesting statistics. We're backed by professional indemnity insurers, so we have a common insurer. No, they're known as the LPLC in Victoria for lawyers, and they publish certain data back to us about the number one claim area. So they don't want claims, so they say, look, guys, we want you to do the best possible legal work without making mistakes, because that costs them money. And I can read to you, I've just brought up here on my other screen, that the number one claim area for mistakes is actually 30%. It relates to conveyancing transactions. Now, we're experts in this field because that's what I love personally is property law and a few other bits of areas of law that we do in the firm. But 30% of all claims, which relates to in excess of $15 million in claims that are paid out. Now, it's there's possible mistakes that can be made. And so if you don't have the right team working for you, either as a vendor or a purchaser, mistakes can be made, and they can be very costly, not only for the lawyer, but also obviously for the vendor or the purchaser. Mm-hmm. And so our game is, out of all the 20,000 transactions, not one claim.
And wow, that's incredible. We talk about this analogy so much to our vendors lately because it's a hot topic and it's current topic, is when they're employing an agent, they've generally got three choices. If their house was a hotel and the sale price was the COVID, they've got three choices to protect it. They could go with the security guards, they could go with the ADF, or they could have the Navy SEALs, which is us, protecting their biggest asset. And I think it is so true when it comes to having someone on your team, which is skilled, which is trained. They know exactly what they're doing. It's like, the surgeon that's performed, like you said, 20,000 transactions, or a surgeon that's done 20,000 surgeries, their hand does not shake when they're starting out again, because almost that's what experience teaches you. That's what, a good experienced agent or a good experienced lawyer can bring to the table. And I also firmly believe you realize the value of having the best on your team when things go south. If it's a smooth selling transaction, no problem, and you'll never even notice the need. But every now and again, and it does happen quite frequently, especially in the interesting circumstances we are living through right now, that something will go south. Someone sees another property and they want to pull out. We've heard stories where a buyer buys a property at auction. They want to pull out of the contract for whatever reason. The first thing they do is they go to their conveyancer to see if there is anything in the contract that's going to help them, get out of the contract and exit the contract because the lawyer or the agent's made a mistake. And that is so crucial, isn't it, Scotty? Like to have that airtight contract. There's no, we always I'm full of analogies today, but the other analogy we use is like the process from the time you list your home to the time you sell. It's like this long corridor with multiple exit doors. And as an agent and as a seller, you want to shut every door along the way as effectively as possible and get to the end and have a really smooth process. And if there's all you need is one or two little escape doors and the whole thing falls apart. How important is that?
Yeah. Can I ask you, Scott? Sorry, I guess on that, what happens if a vendor has signed up with a conveyancer to do their work and stuff happens?
Yep, absolutely.
Things fall apart.
Sure. I actually take a lot of referrals from conveyancers. So I'm not the big bad guy at the end of the day to a certain degree, but sometimes it gets all too difficult for conveyancers and the work will potentially fall out of their scope for the legal issues that are involved. So if you think about conveyancing touches so much more other areas of law. It can affect family law. It can affect corporations law. It can affect different planning regimes. It can affect banking and finance, all those sorts of aspects within law that are really outside the scope from a conveyancer. Now, a lot of conveyancers can be bullied by other parties or other sides in particular legal matters, and they will call on me as from a phone a friend. And I actually put it out to to the conveyancers that are out there that if they've ever got a question, just as long as I'm not conflicted, that they can ask me a question. I don't charge them for that. So I build up good relationships from that perspective. But we do receive a lot of referrals where if something goes wrong, generally it will go wrong in a big way. And typically a contract doesn't allow for damages, so to speak, or an adjustment of price. There's no provision contained anywhere in the contract of sale that allows a purchaser to reduce the purchase price. I'll give you an example. An example is, imagine a purchaser comes along and they do a building inspection. And they do a building inspection and discover that, yeah, the guy got on the roof and had a look at the gutters and he could see that they're all rusted out. There's no provision that allows a purchaser to say, well, I want you to take off $10,000 on the price because the gutters are rusty. And it was just like, well, okay, there's no provision that allows you for that. So at the end of the day, the only way for a purchaser is to actually attempt to try and terminate the contract. Now, they can either terminate the contract because of generally a major structural defect has been identified, and certainly rusty gutters aren't that. Or alternatively, they'll try and pick apart a poorly prepared Section 32 vendor statement, or even potentially kill off the contract. Now, I call them contract killer conditions. So whether or not the contract in itself has been poorly prepared and defective, and then they will try and terminate that contract. And so it all comes down to that one pinnacle point, narrow focus under the microscope is when that contract is signed and what's actually contained in there. And the contract includes the Section 32 vendor statement. And it has to be super deadly accurate. Because if you make a mistake there, then the dominoes will all crash and start falling down.
I find that when we're talking to vendors, that they'll do some shopping around for conveyances and so forth, and a lot of them think, well, yeah, so-and-so has quoted me X, and genuinely, like any other industry, there'll be the cheaper ones and the more expensive ones, but I guess if they do come across any issues, it's going to cost them in the long run.
Yeah, exactly right. I'll give you an example of pricing. As a lawyer, a lot of people think that we charge by the hour, and a lot of my colleagues in the law do charge by the hour. My firm doesn't. We haven't charged by the hour in a long time. Reason being is it's not palatable to the consumer, our clients. So we charge fixed prices. So we put our hand on our heart and we say, okay, cool, our fee is going to be this. And our typical fee for buying or selling a property is $14.95. And that includes everything. It includes all the searches. If you need to make an application for a first homeowners grant, we cover you off for all those sorts of things, or a pensioner concession grant. They're all included. As a purchaser, you can lodge a purchaser's caveat. We recommend that purchasers do that. It includes all that. The only thing that it might not include is an owner's corporation certificate, which can be a few $100s, and they're additional. The other thing is we don't ask for money up front. So if people are worried that they have to fork out money up front, no, they don't need to worry about that. We've had clients use the other conveyancers or solicitors, and then they've come across to us because we've solved a problem or they weren't happy with their service for whatever reason. But at the end of the day, the conveyancing transaction, from our point of view, needs to be, we want to resolve the issue of price with our client from the get-go. If something happens in that transaction that falls outside of the scope of work, so if, for example, the purchaser doesn't continue on with the contract and the vendor wants to terminate the contract and we serve what's known as a rescission notice, that's included in the price. If it goes outside of the scope where we need to litigate, and I'll just talk about litigation as well, is that there may be additional costs there, but before we do any of that work, we will tell the client. We are certainly not the cheapest. I don't want to be the cheapest. We certainly aren't the most expensive lawyers out there. I actually interviewed and hired a new lawyer the other day, and he came from another law firm where they were charging in excess of $4,000 per settlement, which I think is a bit expensive in my book. So, but they were winning clients, and good luck to them. But from our perspective, $14.95 is certainly a most reasonable fee. There's no hidden mistakes, hidden nasty surprises from a price point.
That's awesome to hear.
I mentioned litigation. I just wanted to touch on that, guys. Is that when we're like a seasoned army. not only train a lot and do the work all the time, but also sometimes we've got to get our knuckles bloodied a bit, and that means we need to go into court. And we are certainly not frightened of going into court. So we're regularly in not only VCAT, the Victorian Civil and Administrative Tribunal, we're always in the Magistrates Court, we're always in the Supreme Court, and we're also in the County Court of Victoria. We're in the federal jurisdiction as well. But most of the time, property-related matters fall within the scope of the Supreme Court of Victoria. It's an expensive court to be in. But we certainly don't shy away from it. So we regularly are in the Supreme Court on behalf of our clients in litigating matters, and such, certain things that we get involved with, which come, and when we're in those courts with all the, in excess of 20,000 property transactions that we've done, you name it, we've probably seen it. Removing vexatious caveats that have been put on titles, and the people sit there and go, well, I'm not going to remove that caveat. And we'll go, cool, okay, we'll take you to court because we know we're going to win, and we're confident of that. So we take them to court. We've got another matter on at the moment where a tenant hasn't moved out of a property, and we act for a purchaser. And we're in the midst of commencing proceedings in the Supreme Court for what we call an action of specific performance. Our purchaser must move into this property. It was sole vacant possession. They've got to get in. And so we're going to take them to court too.
Wow.
Wow. There you go. That's what you
Wow.
want. On your team.
On that, you mentioned a couple of things, or one thing, caveats. I often find that, some of the contracts that we receive, you'll see the title and you see the word caveat lodged by X and X. And a lot of buyers start to panic around that.
Yep.
I know for a fact that they're not as bad as they seem. They could be quite minor and so forth, but they do go into panic mode. Can you tell us?
It's a dreaded C word.
Isn't it?
On the contract. That's right.
Yep. Caveat means buyer beware, or caveat emptor means buyer beware. Caveat in Latin means beware. So a caveat at the end of the day is, imagine a padlock, a virtual padlock that clips itself to the title, and it restricts and prevents the owner of that property or the registered proprietor from dealing with that property until that caveat is removed. And when purchasers come along, they look at it and go, ooh, they look at the title search that's contained in the Section 32 vendor statement, and they might see a mortgage, and then they might see some caveats underneath it, one or two. I think I've seen 10 caveats in one instance. And what caveats are, as I said, is that virtual lock that prevents the title from being dealt with. There's provisions in the contract for the purchaser that basically says that the vendor must, at settlement, remove all those encumbrances. And those encumbrances are the mortgage and those caveats. And the vendor has to deliver what we call a good title before they hand over any of their cold hard cash at settlement. And typical caveats that we see, and there's a lot of misconceptions about the concepts of caveats and how people can go ahead and lodge them. So caveats that we'll see might occur in family law, and they're called constructive and resulting trust caveats. And that's where, for example, let's say the husband owns the property in his own name, and his ex-partner may lodge a caveat on there to protect their interest in a family law property settlement. And that's a constructive and resulting trust caveat. A caveat can come about also too, more so in relation to monies that are owed to somebody. Now, people think that just because someone may owe them some money, that gives them an automatic right to lodge a caveat on that person's title. That is far from the truth. A caveat can only come about from a debt when there is a written agreement between the parties, and that written agreement must be written in a very particular way. I've forcefully removed caveats from properties where people have been stubborn and said, no, he owes me money. We ask the question, well, show us the agreement that says it owes money. No, I don't have one. He just promised me. And I said, well, if you don't remove the caveat, we're going to court. And if we end up going to court, you're going to pay all our costs full whack. And that's exactly what happened. They don't listen. Sometimes there are mortgagee sales where a person hasn't been able to meet the repayments of their loans, and the lender has taken possession of the property and sold that property. There's a requirement then also too that those caveats need to be removed, and they can't be sustained. So purchasers don't necessarily need to be too worried about a caveat. My advice is pick up the phone and give my guys a call. The reason being is we offer free contract perusals and Section 32 perusals before anyone purchases. So you can be a confident buyer. We want you to be a confident, educated, informed purchaser before buying. And we'll look at those documents and we can sort of unravel the mystery that's behind the scenes. We've also too got some cool tools, some cool technology that the general public don't have access to. And we can sort of go off and spy on a few things and actually give you a bit of good reconnoiter and do a bit of reconnaissance work for you, make you an informed purchaser along the way.
There's a lot of words there I don't understand.
Yeah, a lot of heavy stuff, mate. We are real estate agents. That's awesome, mate. Thank you so much. A question from me, more so in relation to, by the way, is it okay if I pop your number on the screen so that if any agents want to refer you or call, if any clients want to call you, is that okay?
Yeah, absolutely. Don't give them my mobile number. Give them the 1300 office number.
What's that?
And our office number, 1300 923
yeah
560.
Beautiful. Hope it's right.
Yep. 923 560.
Beautiful. So, question regarding probate. Can someone sell a home without, we've got a couple of clients, obviously deceased estates, very common, makes up, almost 20% of all the sales. Some of them have been advised they're going to wait until the probate happens, and then we hear others that say, no, you don't. So what's your advice on that?
Absolutely. So there's two streams or two avenues in a deceased estate. So when someone passes away and they own a property, they either have died leaving a will or without a will. And they're the two streams. You either die with a will or without a will. If they have died with a will, that will needs to be proved. And that's called an application of probate, or an application for a grant of probate. And that's made into the Supreme Court. Probate means to prove that will. If a person dies without a will, they've died intestate. And they have to apply for a grant of letters of administration to administer the estate. And that's typically the next of kin. Now, the reason why they're so important is this, is a party who is an executor in a will generally can sell a property before probate has been granted. So it allows for the agent to go out there, commence the marketing campaign, the Section 32 vendor statement's prepared. We attach some evidence in there in the Section 32 to prove that the person who's selling, whose name's going to be on that contract, who's the executor or to be executor, once probate's granted, has the right to sell. So if it's probate, yes, you can go ahead and start marketing that property and enter into a binding and authoritative contract of sale. If, however, the person has died without a will and they're applying for letters of administration, they're next of kin, then they apply, they can't sell as on that contract date. I've got some construction work going on. Can you guys hear that?
I'm not
just
really.
a bit.
Can yeah.
Good. Okay, cool. Sorry, I just realised there's a window up. It looks like they stopped. So,
are they in breach of anything for which you could probably take them to court?
No, they're not. They wouldn't be necessarily in breach, but it is a contract killer. And so, us lawyers like to deal in, it sounds like spells out of Harry Potter, but where we say, Lingavia Leviosa or whatever she said in Harry Potter. But a contract, if a contract's been formed and one of the principles of contract law is the parties, the properties, and the price. So if the party to the property transaction is void, the whole contract's void from the beginning. And so that Latin phrase is void ab initio. Sounds like a spell that Hermione Granger would say. But yeah, it'd be void ab initio. So in other words, the contract never started from the beginning. It was void from the beginning. So that's why it's super important to get proper legal advice. And so what we'll ask our vendors and say, well, okay, cool, it's a deceased estate. A lot of the time we do probate applications and we do deceased estate work all the time. I've got a whole deceased estate team actually across our 8 offices. And so we know the ins and outs of deceased estates. And complementary to our conveyancing team, if one of our guys has got a question, an estate may be contested, for example. So a contested will is underway or a contested estate, and the executor wants to sell the property. We may need to call on one of our expert lawyers, one of our partners in the firm, in my firm, a guy called Alex O'Donoghue, who's a legend in contested estates, and he can come up and give some impromptu advice. So you can sell, absolutely, but conditions apply.
Okay.
Huh.
Good to hear. Good to hear. This has been really interesting. I've learned
Hasn't
I've
it?
learned so much. Yeah.
Yeah, I
Yeah,
mean,
I've
I
definitely
know
learned a
I've
lot
been
today.
faced in the
So
past with clients and their deceased estates, and they said it's underway with probate, and from their solicitors' recommendations, they were advised to not put it on the market.
Yeah.
Waiting for probate.
Yeah. Look, and some people can be anti-salesy and get in the way of a transaction.
Yeah.
And I think that can be an overcautious approach, that if someone doesn't necessarily know or is not confident, they'll be risk adverse and say no. So that's why, because of all the transactions that we've done, and we've done plenty of properties where probate hasn't been granted yet, and we know that there's a will, and we've examined that will, and in our opinion, we see that it's a legitimately formed will, then we're very confident that that property can be sold.
yeah.
Volume
100%.
gives you experience.
It certainly does.
Yeah.
We've had some sorry tales, unfortunately, with certain transactions. We've had, you name it, we've seen it. We've had houses burned down in between a contract being signed and settled. We've had, obviously, people lose their paper titles. Titles are now electronic. So most of the titles in Victoria have been converted electronically. So people lose their titles. Deceased estates are a classic where people lose documentation. We've had our clients die in between signing a contract and settlement. And they're sad and sorry things, but at the end of the day, it affects so many people. And if a purchaser dies in between buying and settling a property, or signing a contract and settling a property, the vendors very well may have purchased another property and are desperate and will need that property transaction to go through. So as much as it's sad, there are some strong circumstances which could easily end up in the courts. And we try to avoid that. I certainly don't want to go into court, but I tell you now, I'm not frightened of going into court any day of the week.
We can tell.
So we don't mess around. So we can be persuasive in dealing with disputes. We can be certainly most amicable, and we certainly are. We're professionals. But also, too, we can be quite aggressive when the need arises as well. I think another topic that is really important, and I want to cover off, is like dispelling myths and common misconceptions. You know, everyone's uncle is always an expert, and whenever a nephew or niece goes, "Oh, purchasing a property," "Oh, you know, Uncle Barry knows what he's talking about." and
we meet him every week.
Yeah, exactly. And good old Uncle Barry is the oracle, because he's purchased and sold probably 3 houses in his lifetime. So he's a seasoned expert. We love our Uncle Barrys, don't get me wrong, but there's a lot of misconceptions around deposit releases. And deposit releases, firstly and foremost, in Victoria, in a lot of other states, you can't have access to your deposit monies prior to settlement. In New South Wales, you can. I can't remember the other states off the top of my head, but most of them don't allow it. Victoria allows it. New South Wales allows it. But in Victoria, it is not automatic. And it's certainly, as the saying goes, don't count your chickens before they hatch. So what happens is vendors will list their property for sale. It'll be sold, a property sold, and the deposit is promised. Let's say it's 10%. And you should always seek 10% deposit, is my advice, because if the contract goes south for whatever reason, even if that 10% hasn't been paid, then at least you can sue to recover it. If a person can't, and just stop on that topic there. If a person can't pay 10%, at least write in the contract that they put 10% down, and they pay, say, half of it now and the other half at settlement. Now, this is a lawyer's trick right here. And the reason being is because if they say that they only want to put down 5% deposit, that's going to be the maximum amount you can sue for, is that 5% deposit. It's not 10%. So if you change the contract to 5%, that's all that you can limit it for. But if you put down 10% deposit, they pay 5% now, but the other balance of 5% is due at settlement. And if they don't meet the settlement, then we can sue for the full 10%. So that's an old trick of the trade.
That's a great tip.
It's a good tip.
Yeah, that's
now,
great.
With deposit releases, so let's say a people, when they sell their houses, have a lot of the time has misconceptions that they can easily get the deposit released. It's an easy process. It is a process, and it's called Section 27 because it relates to Section 27 of the Sale of Land Act. And there's a lot of hoops to jump through. but it's never guaranteed. Never, ever, ever guaranteed. So it's what happens is people will then go off and purchase another property, thinking in their minds that, yes, they will be able to pay their deposit from the deposit that's been paid on their house. And they'll just put in there in the contract, I'll pay this deposit by them. It's super important to work with your real estate agent and your lawyer or conveyancer on that front, because nobody wants you to go into a breach of contract. Absolutely not. But people also to understand that, yes, you've sold your house and you're waiting for that deposit to be released. So we can help people craft some conditions to go onto those contracts. So the contract and purchase, sale and purchase process goes through smoothly. So it's always super important. Rule number one, never guarantee that deposit is released. It's just simply not true. Most of the time it can go through. The reason why they generally won't go through is that it requires the vendor to disclose the financial circumstances of their property that they hold. So, for example, how much money is owing on their mortgage, whether they're in default in their mortgage, whether there are any caveats on the property that relate to money, all those sorts of things. And if there is, and the reason why purchasers can be nervous in releasing deposit monies is that if they get to the settlement and the balance of money that they have to pay doesn't satisfy the removal of those mortgages and caveats, then the settlement's not going to go through and those deposit monies are being released and they're not sitting in the real estate agent's trust account. And so that's why that system's in place. I'm a big fan of deposit releases. A lot of my colleagues in the legal profession and conveyancers don't like it because there's a lot of work behind it. But it's lubrication. It's financial lubrication that allows properties to be bought and sold in Victoria. And to me, they're an important part of the conveyancing process. So I'm all for deposit releases. It requires more work. And when a person sells a property, a Section 27 notice should be served on that purchaser as soon as possible to start that process. And we certainly go off and do that for them.
Beautiful.
I didn't realise there was so much work involved. Did you, Kevin?
There's a
lot of work.
This has been unbelievable. So, thank you so much for your time today, Scott. Who's your footy team?
Hawthorn. So we're out.
They're out. Who are we tipping for tonight? Big game, Lions and Tigers.
I really want to see the Lions get up. Yeah, I really want to see the Lions get up. I'm so over Richmond, it's not funny.
Yeah, no, I hope the Lions win. My team, I'll go for Geelong for those of you who don't know, and we had a real embarrassing run last night with Hawkins missing 6 opportunities to score a goal, and my sister didn't understand. I was talking to her on the phone, and she didn't understand why I was so frustrated, and I gave her the analogy because we grew up watching cricket because that's all you do as Indians, and I said, let me explain something. If there was a wicket keeper in a cricket game, they only have one job, which is to just catch every ball that comes. If there's 400 balls at 200 miles an hour, they're just going to catch them. A forward's full-time job is to kick the ball through the 2 sticks, and that's all they specialise in. And when they mix 6, especially when they're a Coleman medal winner, it is just beyond me. Something's really wrong. So I hope they come back next week. But I'm tipping the Tigers as well. And Angela is a hidden Collingwood supporter. She doesn't publicly talk about it too much.
Only when they're on top.
Well, they're playing this weekend. Who are you tipping for tonight's game, Ange?
Well, I only just found out who's playing. So I'll go for the Lions. It was my late dad's team. So for that reason, the Lions.
Beautiful.
Cool. Well, I feel like in our heart of hearts, we think it might be Richmond, but we're all tipping.
Yeah, exactly. No, it's Richmond.
And we are hoping for the best, exactly. So, guys, thank you so much for your time today. Thank you, Scotty. There was so much useful and valuable information. For those
Very
watching,
good, thank you.
This will be viewed by lots of people. We had a few people tuned in today as well. So I've got your firm's phone number on the screen as well. So feel free to call him. If you've got clients that are buying or selling, or if you're looking at buying or selling yourself, if you've got a property pickle going on at the moment, you're in the middle of some drama where you need someone like Scott that'll just, set the record straight and give you really good advice. He's the man to speak to. He helps me personally with my own affairs. So, I can recommend you highly enough, Scott. So thank you so much. Thank you for your time today. Thank you, Angela.